thanks Mary for the introduction. So as she said, what I'm going to focus on today is actually the changes to testamentary trusts and their effect on estate planning. My contact is basically my email there, phelim.o'malley@gmail.com, if anybody has any questions afterwards. Now a little bit about my background. Mary found some stuff on the internet. This is a little bit more of my personal background. I actually started as an engineer. I used to work for CN Rail about almost 20 years. But due to their becoming a stock company, they downsized a lot and I ended up looking for something else to do. Went back to school. I got a generous severance so that I could afford to do that. So I got my MBA in 1997. While I was there, I was actually contacted with people to sit in on a luncheon. I ended up getting into a life insurance industry. Received my CFP, which is Certified Financial Planner, in 1999. I did continue with a lot of other designations, but I've since dropped those. Not that their information was not relevant, but they are no longer relevant to what I am doing. I started with a company that was called Mutual Group. They were a mutual company, which means they're owned by the people that own their policies. They also changed to a stock company, changed their name to Clarica. They existed in that form for about 2 years, and then they got absorbed by Sun Life. I worked for that series of companies from 1997 to 2011. Ended up leaving the company, basically retiring. And I worked there primarily as a comprehensive financial planner. So that's somebody who focuses on analyzing the people's financial needs, not focusing on sales, although recommending products was part of the job. When I was there, let's see, as a comprehensive financial planner, it's what exposed me to all the knowledge that I'm going to help partially present to you today. The first edition of my book was written back in 2014. It was done, it was a pet project I started because I had too much information in my head. I wanted to get it out, get it down on paper. But while I was doing that, my mother passed away. My father died earlier. And as was mentioned before, trustees, we had 5 siblings. 3 were appointed as trustees, basically to try and prevent the sibling fighting. We still had some issues. So that made it, sort of exposed me to some of the other issues. Even though I thought we knew how to handle the estate and we'd done everything the best we could, we still ran into some issues. So that was what finally drove me to publish it. Now I do have to have the little disclaimer. This presentation does not intend to provide legal, tax, and/or accounting advice. It is intended to provide guidance on the issues that should be discussed in detail with your lawyer, tax advisor, and accountant to meet your estate distribution needs and in a tax-efficient manner. And as you'll notice earlier, speaker, fair does not always mean equal. So there's a lot of things to take into account when you're devising a plan. Today we're going to focus on trusts. Just a brief history of trusts. They go back a very long time. I think most of you would think maybe 50, 100, 200 years. They actually go back to the 11th century, feudal England. Yep, the Crusades. Knights were leaving their properties. They were traveling to the Middle East. They put their properties in what was then the primitive version of a trust. So the court decided that it could differentiate between 2 things: the legal ownership of a property, the title, and the beneficial ownership of a property. And that concept has endured till today. It is a very important one when you look at how you do estate planning, because the beneficial issues are some of the more important ones when it comes to court. This applies in Canada, primarily because we inherited the UK or the English system. We are under common law. The only province that it doesn't apply in is Quebec. They have civil law. So when you have estate issues in Quebec, there's really no reference between Quebec civil law and Ontario or any other province in Canada. We are governed under an Ontario Act. Every province has its own legislation when it comes to this, and I think you may have heard earlier things like Succession Law Reform Act, Substitute Decisions Act are provincially based. So even though each province has a similar set of documents, they don't all interpret them the same way. So what works in Ontario may have slight innuendos or differences in other provinces. Also mentioned earlier was fiduciary duty. So once you have assumed the role of a trustee in a trust, you have a fiduciary duty to carry out those responsibilities according to the law. Okay, and you can be held responsible for that. So there's a legal recourse if you do manage to defraud the trust, for some example, or distribute it in a way that was not authorized. To go by the beginnings, the structure of a trust can be very simple in how they set up. They get much more complicated in how they're actually executed. Trusts include, for one, is a trust document. Normally, there is some sort of direction to the trustee to how to distribute or handle the trust. But you can end up with a trust that actually does not have a document. And the one way that happens is, for example, if you went to a bank and you opened an account for a minor child that you're depositing money into and you put it as an in-trust account, that account does not have any documentation, so it doesn't give a trustee any power to distribute the assets of that trust. So what happens then, as mentioned, was that when the beneficiary turns 18, they legally have the ability to withdraw whatever's in that account. That's where the caution comes in. Be very careful how you set up a trust. The documentation can go from very basic, like on a life insurance policy, you may have the beneficiary in trust with a very brief description on what the trustee can do. Or it could go to many pages to very carefully articulate everything that that trustee must do with the funds and the disbursements from that trust. The trustee, you may have heard today, two semi-conflicting opinions on how many trustees you have to have or should have. You need to have at least one. And I'll mention now, you should also have a contingency if that particular one does back out. You need somebody else that can step in that you've directed through your own. Otherwise, it's going to be up to that trustee to appoint somebody else, which may not be to your best interest. In my case, we had 5 siblings. We had 3 trustees, the 3 eldest. Every one of us, obviously being siblings, we are similar, but we all had very distinct characters. I have two brothers, 2 sisters. It was my 2 sisters that we were concerned about because my mom was the last to pass. We knew there was going to be some issues with sentimentality and valuables. The way it turned out, we appointed the sister that would instigate the issues as a trustee. So, and then later had to point out that as a trustee, now she had a fiduciary duty to behave according to law, which kind of straightened things out. It did take a lot of negotiating, however, to settle it. You also have a settlor. The settlor is the one that actually donates or contributes to the trust the assets that are managed by the trustees. So in this case, the trustee takes the legal title, and then the asset goes to the beneficiaries, or is handled for the benefit of the beneficiary or beneficiaries. I'm going to point out now, and actually I can think it's on the next slide. Yeah. Trust gets broken down into 2 categories, and the main driving force, as we'll talk about a little later, is how they're taxed. And this is where the federal government comes in. So all trusts are basically taxed the same way by the federal government through the Income Tax Act. Inter vivos basically means it was set up while the settlor was still alive. The trust, to become an in-force trust, has to have something settled on it while that person is still alive. So historically or traditionally, they would use like a $100 gold coin as a first asset that would come under that trust. That would mean that it's now an inter vivos trust. The second one, which is obviously more important when you're talking about estate matters, although not completely, is a testamentary trust. This type of trust is set up after the person has died. So they don't settle anything in the trust before death, but they have all the documents prepared before death. So the trust is not active. When you determine these two types of trust, this will determine how the Income Tax Act is applied. Now, there are subtypes. There could be a revocable. Obviously, the person would still be alive. They could say, well, a cancel a trust will take everything back into my name. Fair enough. However, CRA says, yeah, but we're going to tax you as if all the income is in your name anyways. Because it's revocable, you can reverse it at any time. Not much use for a revocable trust these days, although a blind trust for a politician may qualify in that capacity. The second one is irrevocable. Just about every trust setup is probably going to be irrevocable. So once you settle assets into that trust, it's there. It does not belong to the settlor anymore. It belongs under the title of the trustee for the benefit of the beneficiaries. A trust is a taxable item or entity. In other words, the trustees do have to file tax returns. They file under a T3. This tax return has to be filed at normally by December 31st of every year, although under previous rules, it was more dependent on the date of death, but the new rules going forward will require it to be based on the calendar year. The trust is not a legal person. So when you talk about something like a corporation, that is a legal person distinct from a person like ourselves. They can be legally sued as a person. Trust cannot. However, the trustees can be held liable. Another thing that they do have in common is that a corporation can be indefinite or immortal, basically. Most people say, how long can that be? Well, Hudson Bay has been around 350 plus years. It was incorporated that long ago in England. There are trusts in force right now that are 150 years. In England, there's an investment trust that's at least that old now. I think some of the previous speakers mentioned that they've got cases where it's going on 25 years, or somebody wanted to hold funds till their son was 60. That can be done. Just hope your trustees live long enough. Which brings us to another important part, is trust residency. So when it comes to taxation, residency of a trust is very important. Now, most of the time it's distinguished by where the trustees live. The trustees will determine if it's in Ontario, the trustees are resident in Ontario, then it will be the federal taxes and provincial taxes that rule. If their trustees live in Alberta, then Alberta tax rules apply. CRA has one more thing to confuse everybody though. They have determined now that the trust can also be determined resident on the basis of its control. So if you go to the Bahamas and you set up a trust and you name a trust company as a trustee, but you live in Canada and you're telling the trustees what to do with the trust and they're just following your orders, CRA says now the trust is controlled in Canada, okay, and under that particular province. So trustees' residency was tested. Unfortunately, it's not ironclad. Now, where I have issues with the residency comes in under a lot of people that I've talked to are more recent immigrants. So they've come here, husband, wife, young kids, but they're the only family here. Their main families are in another country, particularly some from China, Iran maybe. And they say, well, I want to name my parents trustees. And then you have to point out to them that, well, if you name your parents trustees and also guardians of your minor children, everything's going back to China. So you may have to rethink that and hire somebody else, a lawyer, possibly, trust company to take care of your estate. Now, just to give a little bit of background, as of January 1st, 2016, there was an part of the budget from 2014 under the Harper government came into force. And that changed a lot of the rules, okay, as far as trust taxation. One of the things to keep in mind, normally when you transfer assets to a trust, those assets are deemed disposed of by the person settling them. That means that all accrued taxes to that date of settlement are payable. So anything that's accrued up to that date, capital gains, investment income, whatever, will be payable. So anything going into the trust is now fresh. It has no tax liability. There are some exceptions to that, which we will talk about. Right now, the maximum marginal tax rate is used on any income that is taxed within a trust. This has changed over the years. I hadn't expected this when I first wrote my book and thought when I revised it in 2016, it won't be much of a problem, just change a few numbers. Ended up having to rewrite about half my book. So going back to what somebody else had said, if you have a will that's 5 years or older, you may want to reconsider how your estate is set up. Right now, I'm going to say anything you've got done before January 1st, 2016, you may want to reconsider how it's set up, because there could be some impacts from these changes that are going to make you rethink what you had done. And a lot of people should be doing that. Now that rate I quoted is the maximum rate for Ontario. So other provinces have different rates, which is why some people like to have their trustees in, say, Alberta, which might have a lower rate if they want the income to stay in the trust. Trust taxation does not allow you any personal exemptions or tax credits. So it's a straight tax rate. Now, because the trust can continue, the government had enforced, and has for quite a while, what they call a 21-year tax rule. And this can very much affect people who have transferred shares of a private corporation, real estate, into a trust that's supposed to continue for quite some time. So when you hit that 21-year point, all the accrued taxes are supposed to be paid by the trust, and then the count starts over again. So you'll see a lot of people, they'll get to 20 years, 364 days, and they'll be saying, here, take the money, take the assets, get them out of the trust now. Get them into the hands of the beneficiary. Because the beneficiary can receive them without paying tax. But if you leave them in the trust has to find some way to come up with that money. So that can collapse the trust pretty quickly. Now, inter vivos trusts, the Income Tax Act changed in 1999 as far as they were concerned, so there's a lot of people who have had a lot of time to get used to that aspect of it. What it did then was take away all the tax benefits and stick people with the maximum marginal tax rate. So a lot of the inter vivos trusts that were set up at that time kind of became obsolete from a tax perspective as far as efficiency. So just to reiterate, it is at the maximum marginal tax rate for any income tax within a trust. No personal credits again. Now, this is an important point, and this can affect things. So if you think blindly that this is what's going to happen to your taxation when you put things in trust, if the income is distributed to a beneficiary, the beneficiary can include it on their income state tax return. The trust will deduct it, so the trust won't be exposed to the tax. So it'll be out and down. The reason that people complain about this is that when these trusts were set up, a lot of the times the beneficiaries are already financially independent, they're already in a maximum tax bracket. So in the old rules, you could tax at a lower rate in the trust and then distribute capital so that the beneficiary would be receiving capital after tax, no tax implications. So basically it does penalize the rich. It doesn't really hit the small guys. One of the major exemptions for planning purposes is what they call an alter ego, or in the case of two people, a joint partner. Alter ego is a single person trust. Joint partner is two persons. My understanding is they don't actually have to be spouses. They can be brother, sister, or some other relationship. These trusts are very specific in the Income Tax Act. They allow the rollover of the assets into the trust. Any income in that trust can only be used for the person or persons that that trust was set up for. Okay. One of the reasons people use this is confidentiality. When you have a will, and I'm going to say in most cases now they're going to end up going to court, be what we used to call probated, and you get a letter that states who the administrators are. That makes them public documents. So if you're worried about your estate distribution and who might be able to see who you gave your estate to, some people may go this route and actually have confidentiality, because this way it can be distributed to the beneficiaries. Nobody can get access to it. Possibly a court order, but I doubt that. The one drawback to this is when the beneficiary or the settlers pass away, it will remain an inter vivos trust. So if there was any benefits to being a testamentary trust, they're not there. So the tax rate on income tax will go to the 53.5 unless it's divvied out to the beneficiaries. And this was a typo I didn't fix, sorry, got by me. January 1st, 2016 is what it should actually read. The 2014 budget changes came into force. Again, these were brought in to stop people from getting the benefits of lower taxation in a trust and then divvying out capital, which is why we're having a problem with more known as CPP or a CCPC, which is a private corporation, and how he wants to tax people abusing that particular tax structure. And he says, oh, we're going to get the rich people. But if you do it blanket-wise, you're going to hit everybody. And we, as I think was said earlier, we don't know the impacts of that on planning yet because it's not finalized. They're still in discussion stages and a lot of flack. Testamentary trusts were taxed at graduated rates, which means that the same rates that are applied to you going up through levels of income were applied to a testamentary trust. So if it had $50,000, without the personal exemptions, it would pay the same as if you had $50,000 without your exemptions. If it went up to $200,000+, you get the maximum rate, just like anybody else would. And that's on the dollars going up in steps. Now it's going to be taxed under the new rules at the maximum marginal tax rate. So what they did to offset that is they created a couple of scenarios. One is called a graduated rate estate, or GRE. What this does is it gives you an opportunity to take advantage of the old rules, but only a limited period of time. The second one is a qualified disability trust. Because a lot of beneficiaries are in a situation where they are disabled, this was set up to make it more palatable basically for them, but with a few strings attached.
This was also known as a Hansen Trust?
No, this is actually a little bit different. This is under the Income Tax Act. I will talk a bit about Hansen. That's also a very important factor. So the graduated rates estate applies to income for the first 36 months from the date of death. Now there's no grandfathering to this, which means if somebody died 3 years before January 1st, 2016, they're already past that 36 months. So the graduated rates don't apply anymore. Anybody dying after that, they still have a window. But there are some other issues. The graduated rate estate must be designated on the first tax return filed by the trust or the estate. I'm using trust and estate as interchangeable, but they're basically the same thing. You can only designate one estate. This becomes a little bit of an issue because there's rules embedded here that say you can only have one estate, but it excludes a trust set up within a will. Some people have set up their will with an embedded trust clause. So it could be for life insurance, it could be a spousal trust. They do not count under the graduated rates estate. And that's an important factor because there are standalone, but that's another issue. There's one issue that will come up, and that's for people that have private corporations or shares in a private corporation. One of the planning methods we use is multiple wills. What that does is it takes out of your will those assets that are not subject to the estate administration tax. So when you file the court to clear your will, you pay a 1.5% approximately. It's a little less. For the first 50,000, it's 0.5%, but just for general, 1.5. So some people have been trying to take large assets out of their wills. And one of the things that was major asset was shares in a private corporation. They did not require the old probate for their will. So it was tested in court. I think it was a Gronowski case, and they determined that you could have two wills. Usually when you have a will and you write a second will, it voids the first will or revokes it. If you do them both together and they're read together, they're considered one, okay? But you have separated the assets. So only the assets that need to go through probate go on one, the other ones go to another. So you can put in artwork if you got a $40 million Picasso and skip the estate administration tax. So that was the last ruling I've heard on that. Now, the qualified disability trust. It is a testamentary trust. At the end, it has to be a testamentary trust at the end of the year, trust year, this one does include life insurance trusts, but you can only have one disability trust. So if you set up a life insurance trust, it can be eligible. So if you had a large policy, $1 million, $2 million, you want to set aside for a particular disabled person, you could have it go through a trust and a separate trust as life insurance. The trust would be set up while you're alive, the documentation, but not settled until the policy pays to the trust. And as a side to that, if you have a policy like that, make sure your life insurance company knows that the trust is the beneficiary. Make sure you apply for change. If it's still named somebody else's beneficiary, there's a possibility the funds would be paid out in error. The trust has to be resident in Canada. And an election, this is slightly different from the GRE. You don't have to designate it at the first return. You actually have an annual election that this particular trust will be a QDET. No late relief is allowed, so if you missed filing, you don't get the benefit. This one causes a little bit of consternation. You're only allowed one qualified disability trust for a single beneficiary. So if you had 4 disabled people, you could have 4 separate trusts. But if you have 1 disabled person and 4 grandparents want to contribute, you can't set up 4 trusts through your will or estates through your will for that person because they can only designate 1 for the benefit. So some coordination has to be done there to work out how the rest of the estates function with that. The rates apply as long as there is a qualified disabled beneficiary. So as long as there's a disabled beneficiary, they qualify for graduated rates, as long as the benefits are paid out to them. They can receive the after-tax capital, so you don't transfer it to them and have another issue with them filing tax returns and things like that. And I'll get back to Henson in a little while too. If a non-qualified beneficiary, so obviously some people are going to have a disabled person in the trust and non-disabled may be also part of that same trust. So it goes through one estate, you may have 3 or 4 beneficiaries. So if it's a non-qualified beneficiary receives after tax, meaning that you've taxed it in the trust at a lower rate, then you've paid out capital, that will have, there's a clawback provision to take back the payment between the maximum tax rate and the one that was actually paid in the trust. So this is specifically for the benefit of a disabled person. And I don't have time to go through all the rules and regulations today. That would take quite a while. So inter vivos, you have the options, alter ego, joint partnership trusts. Family trust, this one was a very popular one, and this is where the private corporations, we still have to see how that's going to affect things. What they used to do is we'll say, well, we can freeze the value of your shares in a corporation. So say you've got a $2 million share value, maybe almost a $2 million capital gain on the shares of your corporation, and it's still a growing corporation. But to protect the tax issue at death, you freeze it at $2 million value that you own. And that can be done through conversion of the shares, and then you can create new shares. A lot of companies had said, well, we'll put them into a family trust, and then we can divvy out income from there. You don't have to be in a company, we'll just give you money. That was considered an estate freeze, a good part of planning for people with valuable corporations. That is the one that I'm worried about with the new rules. I don't know what's going to happen yet. I don't know if anybody does. Testamentary trust, I talked about life insurance trusts. That's one you can set up as a separate trust document and have just life insurance paid into it, so it will qualify as a testamentary trust. Again, it doesn't go under some of the rules. GRE. Life interest trust. Some people have done things like leave residence in a property to a spouse, and then at the time that spouse has passed away, it goes back to the person's estate. So they've been allowed a life interest in that particular property. Usually it's a residence, just so they have someplace to live. The new rules say that instead of being taxed in the trust, any tax required to be paid on those assets will now be paid by the deceased. So there's a little bit of an issue there to work out. Spousal trust. Spousal trust is identified under the Income Tax Act. It is a special trust. It allows you to roll over assets to the trust for the benefit of the spouse. So you may have an issue with, say, spendthrift. You know, if they get the whole estate, they're going to blow it, lose all the money, not be able to support themselves. So you may set up a spousal trust where they receive the benefits of the income and capital from that trust for their lifetime, hopefully, and then what remainder would go to another beneficiary. Spousal trust has got to be watched, though. You cannot, what they call, taint it by contributing to it from another source or adding a different beneficiary or paying out differently. Now back to your question, Henson Trust. This was brought about by a court case. There's the ODSP, or Ontario Disability Support Plan. Some disabled people don't necessarily qualify for this, but if you do qualify, there's a number of benefits that are associated with it. But there's also a lot of restrictions on it, which means a lot of people, if they are disabled, want to keep their ODSP benefits, but if you leave them, I think it's about $6,000 or may have gone up to $10,000 in assets, they can be disqualified. So this gentleman, Audrey Henson's father, Audrey Henson was the beneficiary, decided to go with a type of trust. It's a name, but it's just, can be an in vivos trust, it can be a testamentary trust. But the main purpose is that the trustees have total discretion or absolute discretion over the divvying out of any of the income from the trust. It was taken to court by the province of Ontario under whatever the law was at that time, or the plan was. It had a different name. They sued and said that because they had the income from the trust, that they were no longer allowed to have the ODSP benefits. Audrey's estate won. They reinstated her benefits, and she was allowed to be paid from the trust. This goes back to where it says absolute discretion for the trustee, beneficial for the beneficiary, but in this case, they determined she didn't have any beneficial ownership. It was only for giving out some income. The ownership would go to somebody else later. Now, I'm going to wrap up a little bit now. One other thing, when it comes to setting up a will, if you're doing it for minor children, when you get into setting up the trust, as was pointed out, the age of a majority is 18 in Ontario. At this point, a beneficiary is entitled to claim all of their benefits under the will. So if they're entitled to $1 million, they can, if they know, they can legally go in and demand $1 million check. And a lot of people say, oh, yeah, but that's not going to happen. We'll make it so that they get so much at 25, so much at 30, so much at 35. And I know from a case I talked to an advisor about, the will did not state a beneficiary should this person pass away first. So the courts upheld that this person at 18 could withdraw their entire estate that they were entitled to. That was a mistake made when the will was drafted. Don't know who drafted it, but this is why, as somebody else mentioned, make sure you get a person that's very familiar with doing estate wills. Don't go to your local real estate lawyer and ask him to do your will, unless you got a very simple one that says my cat goes to my sister. Okay, that's not a big deal. But it's very important that they understand your situation and make sure you understand what the implications are of that situation. In my book, I also go through a few other clauses that a lot of people have neglected to put in their wills that have caused great consternation too in actually administering those wills or getting the people what they deserved out of their estate. There's one more issue here I just want to mention that comes into play, and I think somebody may talk about it later today. It's called a resulting trust. This is an unintentional consequence of somebody setting up something in joint name. So we'll see what can be said for that. Okay, at this point I'll just take questions. I could talk for an hour and a half, 2 hours, but I think I'd lose everybody in the process. I know that's a lot to grasp. It's complicated for what should be a simple issue. Yes, sir.
And when you answer the question, can you repeat the question?
Yes, I'll try to do that. Yes, sir.
If a testamentary trust was set up prior to the January 1st, 2016,
Yes.
what are the tax implications? Because usually, from what my understanding was, that husband dies, leaves wife, instead of giving her directly because she has other sources of income, would roll the proceeds into a trust.
The spousal trust, yes.
It would basically metered out,
Yes.
just not to put her into a higher tax bracket.
Yes.
That basically, for all intents and purposes, is gone. She brings the entire income into her
The entire income, yes.
income into her return.
Yes.
So if there's capital gains inside the trust,
Mhm.
that counts as income for that particular taxation year?
If the capital gain is not realized, that's a long question.
Sorry.
Basically, is how is the tax or the income going to be taxed in a spousal trust now that the new rules have come into force, and one that's been set up before that. So as I said, there's no grandfathering, so the new rules will apply. And also, as I've said, you can actually pay out the income and it will be taxed on their tax return. What the government did was they tried to take away the benefit of taxing it at a lower rate and then paying it out as capital. So that still would be the beneficial way of doing it, would be to divert income. And that sometimes there's not even enough income, they have to pay capital as well. But if you have, say, a capital gain within the trust, as long as it's not realized through a disposition, so you didn't sell the mutual fund or the investment, that is not going to be realized on an annual basis. It will be deferred within the trust, but then you run into a 21-year rule. So you're going to see at 21 years how you're going to deal with those issues of capital gains accruing over a 21-year period, and whether or not you're going to be able to pay the tax or if you're going to distribute it. So sometimes it's better just to distribute as you're going, or if you can make a way of being able to pay the accumulated tax, or develop gains and losses within the portfolio.
What about the instrument within inside the testamentary trust?
Well,
the corporate class or something of that nature?
Corporate class usually refers to a mutual fund that pays out as a capital gain instead of a dividend or interest. The capital gain, you still get the benefit of a capital gain, and half is tax-free and the other half is included in your income. But again, if that half or that capital gain is realized in the trust, you have the choice of taxing it in the trust or transferring it out and taxing it at whichever rate is lower. But since now you're going to be paying 53.5 in the trust, most cases if you pay it out to a spouse, it's going to be at a lower rate. If they're already got $230,000 of income a year, that's the people the government was trying to cap on taking advantage of lower rates.
So then what, in your opinion, is the benefit of a testamentary trust given the change in the legislation?
You actually don't have a control over that, because as soon as you die, you create an estate which will automatically be a testamentary trust. Assuming you have a will, if you don't, it'll be intestate, and then they'll appoint somebody to.
No, in terms of providing for your wife or your spouse or whatever. Is that really now a good estate planning tool or not?
Well, the spousal trust as an estate planning tool is still valuable, because normally when you died and it went into your estate, you would have to pay tax on all the accrued tax due at the death. Spousal trust allows you to roll that over and gain the exemption from having to pay those taxes up front and then starting over again fresh in a trust. So that's the main reason people do it, is a rollover. You still get that with a spousal trust. Divvying the income out is just to protect against depletion more than anything, and keep control over the assets and their income. Any other questions?
I don't know if you can answer this one.
I can try.
All wills have to go through probate in Ontario?
They don't. That's why I mentioned mutual wills, or not mutual, excuse me, multiple wills. A lot of assets are exempt from going through that process if you want to get around it. Two problems come in. One is property. Some property, depending on how it's registered, has to go through the process before they'll appoint a trustee, and now in our terms, it's an estate administrator. The other one is that you may not get access to assets of the deceased without it. Okay, so another,
Frozen, basically. Everything's
well,
frozen.
they'll freeze on death. Yeah, as soon as you notify a company, they'll freeze things. So you can't do anything with it. The issue we ran into is my mother had an investment account, non-registered, no beneficiary designation. So what happened is we went there and they said, well, no, you have to go to the court, get the will probated, come back, and we'll give you access to funds. We said, well, we really don't want to do that. Is there some other way? And they said, well, because my sister had worked there, if we filed the document with them, they would make an exception, and we'd be allowed access. So we were able to get out of that, and then we faced another hurdle. We went to find a bank that would actually set up a trust account with 3 trustees. And they said, well, if you got more than $10,000 to transfer in, we need to probate the will. So I said, okay, now we got to get around another problem. So we kind of got most of the assets distributed, basically. So we reduced it down and got below 10,000. But instead of setting it up in a 3-way with the 3 trustees we had, we just put it in a joint account with one of my brothers and sisters and said, you guys, we're not going to worry about it. It's a few $1,000s, you know, you got to pay expenses and stuff like that. But it's getting very, very hard to avoid going to the court to get appointed. So you either apply as for an estate administrator with will or an estate administrator without a will. And it's, like I said, it's getting very complicated to avoid that. But with a multiple will, you can transfer a lot of value to a will that doesn't have to be probated because it doesn't have to go through a third party or an investment.
So when they assign an administrator, is that the same thing? If it's written in the will that you're the executor, is that they're just saying, stamping, okay, you're the executor as per the will?
Basically, when you're talking about executor or estate administrator, your question being, is it the same thing as a trustee? It's gone through variations in what the actual terminology is, but what it does in purpose is you become the trustee because you now are responsible for the ownership legally of those assets for their distribution to the beneficiaries. So that's why things like shares in a private corporation, you really don't need the court to appoint or approve your appointment. But as you go through that process, they also come back to you and say, well, we need to collect the estate administration tax. So whoever applies has to come up with the money to put to the courts for the estate administration tax. So I didn't, well, in a large estate, it basically is 1.5%. And I'll echo some of the other things that were said. It's sometimes very preferential to pay that 1.5% than to go through the whole process of trying to avoid it. Mm-hmm. And I know the gentleman this afternoon is also going to speak on some of the other stuff that gets you in trouble with that.
And how long does it usually take to clarify, like the probate, once you go with your will to the court and have it probated? Is it a month, 2 months usually? Or?
It's usually a fairly short process. I think it can take up to 6 months though, but it shouldn't take that long. The only reason you're going to get into trouble is if somebody else applies and says, no, that's the wrong thing, we want to be appointed. Especially even in an intestate situation, you could run into some pretty tough stuff because you're going to get more than one person who says, I want to be in control of mom's estate or dad's estate. So you might get one brother saying, I'm going to apply for it, another brother will say, I'm applying for it, and then the courts have to decide who does it.
Whatever, that's why I'm confused about whatever is written in the will. If you're assigned as an executor in the will, like that person assigns you and someone else as an executor, the court can change that?
No, the court can't change it if it's in the will and the will is valid.
Okay.
So what the court is saying, again, I'm not rephrasing the question. When it comes to your appointment through your will as to who you want to be
Right.
your trustee, the court basically is going to rubber stamp it if they can prove that that's who you are,
Okay.
or you don't want to back out. But if somebody dies intestate, they don't have a will, and then you want to go to court and apply to be appointed, you could get into a lot of issues there. So that's where we usually run into some of these litigation issues. You get an intestate person and everybody comes out of the woodwork saying, I want to run the estate.
Yeah.
So that's, and if there's no will, there's no definition on how the person can divvy it up,
Yeah.
except that it goes by the rules under Succession Law Reform Act. As mentioned earlier, with the wife that married the very elderly person, she got $200,000 plus probably 1/3 of the remaining value of the
Yeah.
estate. That's the estate. And I'm going to make a differentiation here. If there's anything in the estate of the person that has a beneficiary designation, like life insurance, like an RRSP, or TFSA, RIF, anything of that nature, they bypass the estate unless the estate is named as the beneficiary of those. So a lot of people will buy life insurance and say, I'm going to spend everything and just die and let them have the life insurance.